Hi guys, today I'll be talking about the topic of frustration. The purpose of this video is to help law students who already have some understanding of the law. It is to supplement lecturers, not replace lectures. Like normal lecture usually lasts for 2 hours. Here I target to only present about 15 minutes. So this is the structure. I will go first, I'll explain what is frustration, and then I'll explain how to use hardship and force majeure clauses, and then I'll apply the test to some problems, and I'll give some reasons for the strict test. I'll explain what are the effects of frustration and what the steps parties need to take when they claim frustration. Okay, historically, parties to a contract have to perform even when an event causes performance to be impossible. This was the rule laid down in Paradigm and Jane in 1647. 100 years later, the law was changed in Taylor and Cadwell, and the judge gave his reasoning that if an event causes the contract to be impossible, the parties did not imply to the parties implied to agree that they will no longer be bound. So in this case, a music concert hall was burned down, so the contract was held to be frustrated. Later on, the reasoning for the doctrine of frustration came in Davis Contractors, where it says that sometimes the term cannot be implied because it is not obvious that it went without saying, so it doesn't meet the test for implied term. Lord Reed say it depends on the true construction of the terms, which are read in light of the nature of the contract and the relevant surrounding circumstances. So Lord Reed is saying that the doctrine of frustration comes about because when the parties enter into the contract, what they agreed had become radically different from what it is now. So it requires it doesn't just require impossibility as in Taylor and Cadwell, but radically different can also amount to frustration. And there is no requirement that the contract that it be just to terminate the contract. So yeah. So just because the judge thinks that it is just, he will not declare the contract to be frustrated. Rather, he has to look at the terms of the contract, what the parties actually agreed, and if the situation now is different from what the parties originally agreed, then it will be frustrated. So what are the elements of the test? So in Davis Contractors, the event must make performance of the contract impossible or illegal, or the contract is now radically different from that originally agreed to. So there are 3 situations. 1 is impossibility, 2 is illegality, 3 is radically different. And there must be 2 criteria must be met, that the event must be unforeseen and beyond the control of either party. If it was within the control of one party, it will be a breach of contract and the right remedy is to claim for damages. Frustration causes both parties to be discharged from their obligations and the contract is terminated from the date of frustration. So we can see that the event is the effect of frustration is very drastic, and some parties, they don't want the contract to be terminated. All they want is more compensation, right? But we can see that if you terminate the original contract, you can renegotiate for a new contract. So it's a very useful remedy, but the courts the court seldom declare contracts frustrated. Okay, if they are implied or expressed terms, the terms will govern the obligations of the parties, right? So if they are, let's say, COVID-19 is mentioned in the contract as a term, then the doctrine will not apply, right? So it's only where you can prove, the party seeking to prove frustration, rely on frustration, will have to prove that the event was not explicitly mentioned in the term for him to rely on the doctrine of frustration. So an example of an implied term is amalgamated investment, right? So the buyer of a shop lot wanted to terminate the sales and purchase agreement after the government changed the status of the property to historical. So as a result, the property can no longer be redeveloped and the market value has fallen. Right? It fell by quite a few million pounds. Right? But the court held that it was a breach of contract. Right? The contract had not been frustrated because the buyer, the risk of a change of status fell on the buyer because the buyer had impliedly assumed the risk. Next is I'll talk about beyond the control of parties. So one example, it can be seen in the case of Super Servant 2, where the contract was to transport an oil rig, but the ship, the party had two ships, one ship sunk. So he had two contracts, but one ship sunk. So he had a choice to allocate a ship to perform either of the contracts. So the contract that he did not perform amounted to a breach of contract. Okay, because the court held that he had a choice to decide which contract to perform. So this rule is very harsh, and the parties must specifically state which ship to use. So if that ship sinks, then it will be impossible for that ship to be used. So it can be also, another example is where there are two factories and one burns down. If the other factory can still supply the goods, then it will not amount to frustration, unless the contract specifically says the goods will come from one factory. Okay, now I'll explain about impossibility. In Davis Contractors, labor shortages caused a 14-month delay. It was to build 70 over houses. The court held that it was not impossible, right? Because the court interpreted impossibility as physical impossibility. So it is still physically impossible to complete, just that it will cost more. It also can be seen in Tusky Rock Low, where the closure of the Suez Canal did not frustrate the contract because the ship could still take a longer route, just that you had to go around the continent. And the goods were peanuts which were not easily perishable. So world economic downturn also did not amount to a frustrating event in Thames Valley, right, where the price of gas rise and the supply of gas was no longer economical. In fact, it will be making a loss. But just because you will make a loss does not amount to a frustration. This right. So and in Blackburn, even if you are unable to find supplies for your goods, okay, it will not be frustrated. So we see examples of events that does not frustrate the contract. So when actually does it amount to frustration under impossibility? So it's this is we find very few cases because the UK courts only recognize physical impossibility, but in US they have legislation where frustration will occur if it is commercially impossible. So if it becomes the price has gone up by a lot, significant increase in price, then the contract will be frustrated. So treaty on contracts, this is an academic, a very authoritative academic in contract law in the UK, also suggests that commercial impossibility can cause frustration. But so far, I have not found any cases from the books that allows commercial impossibility in UK. But Malaysian courts, there is allows commercial impossibility. So, for example, there's this case where a developer of a high-rise apartment only managed to sell about 10 to 15% of the units. After trying very hard to sell the units, the court held that the seller wanted to cancel the project and refund all the money, but the buyers disagreed. The buyers say that now you have to compensate us for interest, loss, and loss of opportunity, right? Because it's a breach of contract. But the Malaysian court held that it is frustration. It is frustrated. Okay, what is forcibility? Forcibility can be seen. Forcibility doesn't have to be strictly followed. In the case of Eugenia, Lord Denning said sometimes the contract can be frustrated even when the event was foreseeable. So in the case of Eugenia, the parties actually foresaw that the Suez Canal might be closed due to war, but it was so unlikely, the probability of it happening was so unlikely that they say that they will, if it happens, they will leave it to their lawyers, so they didn't want to include it in the contract. But Lord Denning still say that he was frustrated, even though it was foreseeable because the probability was so low. Illegality can be explained by the case of national carriers. So, motor vehicles to a warehouse was blocked by authorities. It was more than 20 months, but the tenancy was for 10 years. So the court held that the blockage was only temporary. So illegality has to be permanent. So if the authorities only declare it to be illegal for a short period of time, it may not amount to frustration under illegality. So it depends on how long the tenancy agreement is and the proportion of the period that it is illegal to perform. Okay, what does radically different mean? Okay, radically different can be explained by a change in the purpose of the contract. So radically different usually applies to buyers instead of sellers. Okay, impossibility is the seller is impossible, doesn't find it impossible to perform. But radically different is more for the buyer to say that the purpose of the contract has changed. It can be seen in the two coronation cases. Okay, one was frustrated, one was not frustrated. Okay, so a person wanted to rent a flat to view the coronation of the king, but the coronation was cancelled. The flat was no longer useful for him. The court held that it was frustrated because the flat had no other purpose. Right? So, but in another case, the person hired a boat to view the coronation and the fleet of the Royal Navy. So you can see there are two purposes. So when the coronation was cancelled, the court held that it was not frustrated because one more purpose, which was to view the fleet of the Royal Navy, could still be performed. Okay, so we have explained what are the what are the 5 elements for frustration. So if parties don't want to rely on the doctrine of frustration, they can include hardship or act of God clauses. Right? Hardship clauses doesn't need to be impossible. Means the performance can still be possible. Maybe it becomes more expensive, right? So you can provide, right? Let's say the cost has risen. So if the cost has risen, you don't need to cancel the contract. Maybe you can say if the cost has risen by 10%, then the price goes up by 10%. Right? So if you can't find supplies, maybe there can be extension of time, right? And in the case of a buyer, if you lose your job or you are unable to get a bank loan, then you can terminate the contract, right? These are all hardship clauses. So the words must be precise. The word prevents performance, okay, usually means impossible. But if you use the word disrupts performance, then you can say it makes it harder to perform, and it can fall under the hardship clause. So whether you use prevent or disrupts, right, will significantly affect your ability to rely on this clause. Act of God clause can also be used. Act of God is normally interpreted as a natural event. So natural like earthquake, anything that happens naturally. And it will need to be both of these clauses need to be clear, because if it's not clear, the court will interpret it against the party seeking to rely on it. So one example is there was a world economic crisis in 2008. So the buyer of aeroplanes did not want to take the aeroplanes anymore because nobody was traveling, right? So the clause that he was seeking to rely on was any other cost beyond the purchaser's control. This was not wide enough to cover economic downturn, right? So if you want economic downturn to be covered, you should put economic downturn, economic crisis, and yeah, so it has to be specific enough. So some practical examples to see whether we understand how this doctrine applies. There are three here. One is if a wedding is cancelled, okay, does the customer still need to pay the hotel or restaurant? So it can be radically different because you have there's no relatives or guests to eat the food, right? But the hotel will say it is foreseeable and performance is strict, right? You have to perform because there's no clause to exclude your liability. But the customer will then say it's unforeseeable. So which party you have to see whether there are any precedents in the court. And yeah. And in the case of a tenant, let's say COVID-19, due to COVID-19 lockdown, the tenant can't operate his business. So if the tenant is going to be bankrupt and is unable to pay, it could amount to impossibility, my opinion. But if you argue under illegality, it also may not be long enough, right? Because lockdown is only 3 months, whereas the tenancy agreement is for 24 months. So it's only for temporary. So illegality may be harder, whereas impossibility only if the tenant is going bankrupt. Stop order. Let's say a contractor is issued with a stop order by the government. The contractor has to say that it was not his fault. He has to prove that it was not his fault. And the stop order may not be permanent. It could only be for 2 months out of 3 years contract. So it is very hard to say that the contract is now terminated due to frustration, right? Okay. So we can see some 3 reasons why the UK courts are applying a very strict test. One is to prevent parties from escaping from bad bargains by claiming any unfavorable event as a frustrating event. So whenever economic crisis comes, we don't want parties to say that the contract is frustrated and terminated. Or let's say a drop in oil price, a drop in gas price, right? And UK parties usually have lawyers to advise them. So they want to encourage the parties to include events such as COVID, such as impossibility or illegality into their contracts, right? And one more is because we already seen that the effect of frustration is to render the contract terminated. So it should only be used when it is really necessary. Okay, so we have already explained the one effect of frustration, which is termination of obligations. But how about monies paid? So under common law means traditionally under case law, whatever money that was paid was not recoverable. Whatever money was due to be paid is still payable. But UK and Malaysia has enacted legislation where whatever money that was paid is refundable, and whatever money that is due is no longer payable. Correct? So Malaysia basically based their legislation on the UK. But then the seller can deduct expenses incurred. 1 and 2, any benefit given to the buyer. Okay. So steps to take. So if a party wants to claim frustration, first it needs to notify the other party. If the party disagrees, then it will be up to the court or mediation or arbitration to decide. But if the party agrees, then you can terminate, or if not, you can renegotiate for a new contract. If you renegotiate for a new contract, it should ideally be in a deed. A deed means it has to be signed and witnessed in the UK. Right? Otherwise, the other party can claim that he was mistaken in law and there was no fresh consideration for the new promise. This only applies to UK. In Malaysia, the mistake doesn't affect the contract. So even if you are mistaken as to law, okay, even if you are mistaken as to law, as to Malaysian law, you cannot escape from a contract. Whether it is oral or whether it is written, if you are mistaken whether the contract is frustrated or not, it will not affect the second contract, the new contract. And also Pinal's case doesn't apply. So whenever you sign a new consideration, whenever you sign a new contract, no new consideration is required. Right, so this is the difference between Malaysia and UK. And also for both countries, there must not be economic duress for the new contract. Right? If one party says that I will not perform the contract unless you pay me more money, right? So it could amount to economic duress if the other party, let's say, is having cash flow problems, right? And it needs the money urgently. So it is economic duress. But if there are lawyers advising both parties, let's say both parties have lawyers advising, then there won't be duress, right? Because both parties have their legal advice. That's all.